Good evening. Welcome to Thursday, June 25th, 2020 of Kern County Planning Commission hearing. I will officially call this meeting to order. Madam Clerk, can you please start the roll call?
Mr. Ashley?
Here.
Mr. Ditt?
Here.
Mr. McGivney?
Here.
Ms. Skidmore? Here. Mr. Sprague? Mr. Hall?
Here.
Mr. Murphy?
Here.
Ms. Slayton?
Here.
Ms. Simons?
Here.
Perfect. The County of Kern provided notice that as a result of the declared federal, state, and local emergencies due to the COVID-19 pandemic, and in light of the governor's order, this Kern County Planning Commission meeting is not physically open to the public. Testimony and general public comment are accepted via email or voice message to the clerk of the commission prior to tonight's meeting. And live comments via teleconference will be held during the meeting. If you're interested in providing comments on any item on this agenda and have not already received direction on how to do so, please contact the clerk at area code 661-862-8647. We will begin tonight's meeting with commission members' announcements or reports.
I'd like to speak, Mr. Chairman.
Yes?
Thank you,
Go
Mr.
ahead.
Chairman.
Mr. Giffney?
Recovery from this pandemic has certainly had its ups and downs. We are learning how to adjust our public behaviors in this situation as we try to understand its ability to spread, which seems almost immediately at random, no matter what we do. Nonetheless, in most cases, common sense has prevailed, oftentimes over the advice of purported experts, and the action by our local public health leaders in concert with the governor has been thus far successful overall. The vast majority of our community cares about each other's health and prosperity. Our job here at the Commission is to ensure that happens as we consider each petition for a project. As we look towards our future opportunities in Kern County, we also need to see a proper role for governmental influence. We cannot abuse regulation, become a cudgel to inhibit growth in areas that desperately need it. Government needs an expanding tax base for being able to meet its commitments to the public it serves. Traditional Keynesian methodology to economic revitalization has been to use taxpayer investments, such as the New Deal under FDR or Great Society under LBJ. However, other methods of economic revitalization, such as enterprise zones, remembering Jack Kemp, have been embraced more recently. And we have a county that is eager to engage those who are willing to invest here to help us grow and flourish. In any case, no matter what the method, our Commission's role is to help make sure that any action taken by government or otherwise is legal and in concert with the best interests of the public. But that said, there are competing forces in our nation that do not see things in the same way with respect to building communities that have successful long-term growth. Today, we see that some of our citizens are demanding a defunding of law enforcement. While mistakes and abuses by anyone involved with law enforcement are troubling and costly to the county in terms of settlements and unrest, to answer this with a call to eliminate it would be a great mistake, ultimately leading to vigilante justice and a rapid decline in economic activity. The reality is that there is no one who will set up a legitimate business on purpose in an area that is not safe for conducting commerce. Those who are most vulnerable economically will suffer the most with a reduced law enforcement capability. Absent of a safe community where people can conduct business without fear of crime, we will only see more economic suffering, not less. We can certainly hold our public officials accountable for their action or inaction, but we should not put the lives and livelihood of our people and businesses at risk because of hate and discontent. Safe, functional communities are ones that will grow and prosper. We only overcome economic imbalance, perceived or otherwise, with an infrastructure that encourages and protects all rights and grants opportunity for everyone. Defunding law enforcement does neither and is not a compelling strategy for long-term prosperity. Thank you.
Thank you, Commissioner McGiffney. Prior to moving on, I also just quickly would like to welcome back Mrs. Skidmore. It's been a long time, and congratulations on the new addition to your family.
Thank you.
Moving on to approval of minutes of June 11, 2020. If any fellow commissioners have any comments, otherwise I'll entertain a motion.
Move to approve.
Second.
All in favor?
Aye.
Aye.
Aye. Item number D, case of withdrawn or request for continuance. I will now turn to Mr. Murphy to comment on these items.
Thank you, Mr. Chairman. Tonight, we actually do not have any items under D, cases withdrawn or request for continuance.
Seeing that, we have Consent items, moving on to item number 3, consent agenda. Mr. Murphy, I'll turn to you on the consent agenda.
I will. Thank you, Mr. Chairman, members of the commission. These are items that are scheduled before your commission, which are being recommended for approval by staff, and the applicant has been informed of any special conditions and has no objection. The hearing on these items may be expedited if no member of the commission or audiences wishes to comment or ask any questions on the case. This evening, we have one case on the consent calendar. That is case number 3. Case number 3 is track 6100, an extension of time. The applicant is United Rosamond LLC by Cornerstone Engineering, Inc. This project is located on the east side of United Street between Hastings Avenue and Fellside Avenue in the Rosamond area. The specific request is an extension of time for a period of 2 years for vesting tentative track map 6100, which proposed to divide an approximately 60-acre parcel into 252 single-family lots that all range in size from 6,000 square feet to just over 14,250 square feet. There is one sump lot also associated with this project. The project also includes 4 limited design variations, development variation to allow single-family residential lots less than 2.5 acres in size and having less than 100 feet of street frontage to take access off a secondary highway alignment. The staff recommendation is to approve a 1-year extension of time from May 6, 2020 to May 6, 2021, subject to the original conditions of approval, with the inclusion of additional condition requiring the payment of traffic impact fees in effect at the time building permits are applied for on any lot within the recorded map or phase, and with the inclusion of additional condition requiring the development of track 6100 adhere to current adopted development standards. Staff recommends you adopt the suggested findings as set forth in the attached draft resolution. That completes the reading of the consent calendar.
Thank you, Mr. Murphy. So prior to moving on or having a motion, are there any public comments, Madam Clerk, that are submitted on any of this consent items today?
No, there were not.
There were not. So moving forward, we will close that option for public comment. Any fellow commissioners want to comment on this item prior to making a motion? Seeing none, I would entertain a motion.
Motion to approve.
Second.
Hold on just a second. Oops. I just had it. There you go. 4 ayes, 1 absent. Sorry.
Perfect, thank you. Moving on to item F, public presentations. Would we not have any tonight?
Chairman, Judge, we would potentially have some presentations, I'm not sure, but before we get to that, I'd like to read the appeal process.
Oh,
The
yeah,
track
thank
map
you,
is
Mr. Murphy.
final condition unless it is appealed.
Did overlook that. Thank you for the clarification.
Sure. So for projects where the Planning Commission action is final, those actions are subject to appeal to the Board of Supervisors by any interested person. No development proposed by any application may be authorized until after the final date of appeal. An appeal may be filed with the Kern County Planning and Natural Resources Department. Our office is located at 2700 Suite 100 in Bakersfield, 2700 M Street, Suite 100 in Bakersfield, with a filing fee of $540 on forms we have available at the department and on our department website. For track maps, an appeal must be filed within 10 days from the date of decision of the Planning Commission. Again, that appeal must be accompanied by an appeal fee of $540. If no appeal is received, the action of your commission is final.
Thank you, Mr. Murphy, and thank you for that clarification. Now, moving on. Madam Clerk, are there any public presentations or anyone that's called in to speak on items that are not on today's agenda?
No, there have not been.
Okay, being that, I'll close public presentation. Moving on to adjournment.
Nope.
Am I missing something again today? Public hearings? Okay, so is there any public hearings, Madam Clerk, we should be addressing?
We do, Mr. Chairman. We have 2 items on the agenda tonight. So the first, we will have a staff presentation from Ms. Katrina Slayton on item number 1.
Am I missing something here? Okay, so we'll turn to the public presentation.
Good evening, Commissioners. So the project before your commission tonight is the AV Apollo Solar Project by Lend-Lease Energy Development. This project is The proposed project is a 60-megawatt solar facility with up to 360 megawatt-hours of energy storage capacity, located approximately 8 miles northwest of the unincorporated community of Rosamond within the boundaries of the Kern County General Plan. As shown on this map, the project consists of 3 individual contiguous sites totaling approximately 493.5 acres of privately owned land. A breakdown of the project site by APN is shown on page 3 of your staff report. None of these parcels are subject to Williamson Act land use contract or designated as prime farmland, farmland of statewide significance, or unique farmland as determined by the Department of Conservation. The entire project is located within a 100-year floodplain designated as FEMA Flood Zone A. The nearest residential structures to the project are located within 250 feet, specifically located northwest at the intersection of Trotter Avenue and 100th Street West, southwest of the intersection of Bacchus Road and 100th Street West, south of the southern project site boundary, and east of the Tehachapi Willow Springs Road. The action before your commission tonight pertains to 4 conditional use permits. I would like to point out that the project was originally noticed as including an amendment to the circulation element of the Kern County General Plan. However, that request was subsequently withdrawn by the applicant. Nonetheless, that case number, GPA number 5, map 214, remained on tonight's agenda so as to not to cause any confusion that this is a different project. A complete listing of the requested actions has been provided to your commission on page 4 of your staff report. If approved, this project would include the authorization to construct a 60-megawatt commercial solar photovoltaic power generating facility and associated infrastructure, such as battery storage facilities, transmission and gen tie lines, and operation maintenance facilities at each site. The project site would be accessed from various roadways. The northern solar facility would be accessed from Bacchus Road, Maxwell Avenue, 100th Street West, and Trotter Avenue. The 2 southern facilities would be accessed from Bacchus Road. The project's construction water demand is estimated to be 147 acre-feet over a 14-month construction period and approximately 6 acre-feet per year for operations thereafter, which includes panel washing and dust control. Non-potable water would be obtained from an existing well adjacent to the project site or by up to 3 proposed on-site wells. Potable water would be brought to the site via water trucks for drinking and domestic needs for construction workers. An environmental impact report was prepared for this project in accordance with the California Environmental Quality Act guidelines. To initiate this process, a notice of preparation was prepared and circulated for a 30-day public review period beginning on August 18, 2017. A scoping meeting was held on September 7, 2017, in which no verbal comments were received. A total of 9 comment letters were received during circulation of the notice of preparation. Based on the analysis contained in the initial study and those comments received, a draft environmental impact report was prepared and circulated for a 45-day public review period beginning on December 23, 2019. In total, over 120 copies of the draft EIR were distributed for review, along with over 150 notices of availability. Staff received 13 written comment letters from individuals or agencies during that 45-day public review period. An additional 2 comment letters were received after the 45-comment review period. As required by CEQA Section 15088, responses to these comments were prepared by staff and distributed at least 10 days prior to the consideration of project by your commission. During the course of processing this request, staff has notified all affected agencies, county departments, and property owners within 1,000 feet of the project area. As a result of that notification, staff received 3 comment letters. These comments have been provided to your commission as attachments to your staff report. Subsequent to the preparation of a staff report, a letter from one of the initial interested party commenters, Adams, Broadwell, Joseph, and Cardozo, was received, stating that all of their comments was addressed in the county's response to comments and revisions to their EIR. This letter was provided in your addendum tonight. The final EIR consists of 3 volumes, which has been provided to your commission and posted on the Planning Department's website. The final EIR contains 53 mitigation measures to reduce project and cumulative impacts associated with this project. The proposed mitigation measure monitoring program, listing all of the required mitigation measures, has been attached to your staff report as Exhibit C for review. Pages 7 through 13 of your staff report provide a summary of the environmental determinations included within the EIR. While most of the project impacts can be reduced to a less than significant level with implementation of the required mitigation measures, staff has determined that implementation of the project would result in a significant and unavoidable project and cumulative impact to aesthetics, cumulative impacts to air quality associated with the temporary construction activities, cumulative impacts to biological resources for loss of foraging and nesting habitat, and cumulative impacts to wildfire due to the project's rural location. As I noted, the proposed project includes 53 mitigation measures to reduce these identified significant impacts to the extent feasible. As required by CEQA, the EIR included a series of proposed alternatives, including the no project alternative. Because the no project alternative cannot be the environmentally superior alternative under CEQA, the environmentally superior alternative for this project is the no ground-mounted utility solar development alternative. As I said previously, staff did receive 13 comment letters during the circulation of the environmental document and 2 additional letters after that 45-day comment period. A summary of those comments and responses are included on pages 16 through 21 of your staff report. Again, a letter was subsequently received from one of those interested parties stating that all of their comments had been addressed. In addition to the agency and interested party comments received, staff received 2 comment letters from surrounding property owners. These comment letters expressed concerns related to the solar facility and its proximity to existing property and residents. Specifically, the comment letters brought up questions or concerns regarding why this project location was chosen, the ownership of this proposed project site and the relationship between the owners and the applicant, property negotiations, whether the applicant will profit, and loss of access to property. So I'd like to take a minute to respond to a couple of those questions. Staff notes that project properties are selected by the applicant and are based on leasing or purchasing agreements between the applicant and the property owners. The relationship between the applicant and property owners is a private matter between those parties. Property negotiations are not under the purview of California Environmental Quality Act and may take place outside of land use determinations, privately between the property owners and the project developers. Information regarding profit is not required to be furnished. However, staff has received letters of authorization from all property owners included within the project boundary. Regarding the loss of property access, according to the submitted title reports, the proposed project would not obstruct any access easements. We note that Bacchus Road and Tehachapi Willow Springs Road are both public access easements, and additionally, a public access easement exists along the west side of the southern project boundary, as shown on Figure 6 of your staff report. As you may recall, this project was previously scheduled for the June 11th agenda, but was continued to tonight. However, one member of the public, Ms. Heather Thomas, called in and was allowed to provide comment at your June 11th hearing. Ms. Thomas commented that the Antelope Valley community of Los Angeles County, where she lives, is suffering from health issues due to dust particulates as a result of the number and size of solar facilities being built in the southeastern portion of Kern County. Ms. Thomas claimed that air emissions for the solar facility industry are significant and unmonitored, and that no more facilities should be built in the area. I would like to note that the Eastern Kern Air Pollution Control District has extensive dust control measures that are applied as project mitigation measures or permitting requirements for all commercial-scale solar projects within their jurisdiction. Since the implementation of these measures in 2015, dust control measures have been controlled and limited from the commercial-scale solar projects in Eastern Kern, and localized impacts are responded to appropriately by the district. While it is true that cumulative impacts of all solar projects in the vicinity of Eastern Kern, including those in Los Angeles County, may have an impact on the Antelope Valley, it is at the discretion of the appropriate air quality district to manage impacts from solar projects within their jurisdiction. Staff believes that the cumulative air impacts have been adequately addressed and mitigated for in the EIR's cumulative air impacts discussion. Ms. Thomas also claims that the photovoltaic solar panels proposed are not as efficient when compared to thermal solar panels. Staff notes that thermal solar facilities producing more than 50 megawatts can only be permitted under the California Public Utilities Commission, which excludes Kern County from the land use process. From an environmental standpoint, thermal solar panels require more water usage than photovoltaic solar panels. The process requires mirrors to redirect sunlight to a focused location to heat water to generate steam, which in turn produces the electricity. In addition, the biological impacts of avian mortality of thermal solar panels are generally considered to be greater than photovoltaic solar panels. Staff did receive an additional letter from the Kern Audubon Society just this afternoon, and Mr. Murphy will speak to those comments.
Thank you, Ms. Slayton. Again, as mentioned a few hours prior to tonight's hearing, the National Audubon Society, Defenders of Wildlife, and the Kern Audubon Society submitted a comment letter regarding the proposed project. Within that comment letter, they indicate that the Apollo Solar Project EIR is woefully deficient, filled with incorrect statements and misrepresentations unsupported by substantial evidence, and they are requesting that this document be recirculated for public review. We have provided an addendum to that particular letter, and I'd like to just to summarize the comments and staff's response at this particular time. So again, the comment letter specifically identifies concerns with the analysis related to the Swenson's Hawk, specifically the location of potential nesting sites that are located within 5 miles of the site, and then also impacts that they would impacts that this project would have on foraging habitat for these species. The biological assessment prepared for this project was done in July of 2017 by a team of biologists with QK consulting firm. Curtis Obtain was the principal biologist, and David Dayton was the senior environmental scientist. Both of these biologists are highly certified and considered experts related to endangered species and also survey research. Copies of their resumes have been attached to this addendum staff report for review by your commission. Based on the surveys that were conducted in April, May, June, and July of 2017, the biological report concluded that no Swenson's hawk nests were located on site, and there were no potential nesting sites located within 5-mile radius of the project site. Further, they indicated that the proposed land that the development would be constructed on is considered to be low foraging habitat for the species, as it does not include Joshua tree woodlands, irrigated alfalfa, or any low-growing row crops. Based on the results, the EIR prepared for this project concluded that no specific project-level adverse impacts were identified for the Swenson's hawk. However, the EIR did acknowledge that a combination of this project with other related similar projects would result in a significant and unavoidable cumulative impact to the loss of foraging and nesting habitat for special status species. So during the circulation of the draft EIR, staff received comments from both the California Department of Fish and Wildlife along with the National Audubon Society, indicating that according to the California Natural Diversity Database, there are potentially 3 sites, nesting sites located within 1 mile southwest of the proposed project site. Based on that comment, staff recommended some revisions to mitigation measure 4.4-12. We were already requiring a pre-construction survey to be done prior to the development of the site before any building or grading permits take place. We added specific language to include that pre-construction survey would also include an analysis within a half mile of the project site to ensure that there were no active nesting habitats at that time. If there are, then the applicant would be required to consult with Fish and Wildlife, to determine necessary buffers and if any other measures were needed to reduce those specific impacts. The lead agency does not consider low foraging habitat that is devoid of Joshua tree woodlands, irrigated crops, and with no evidence of presence that meets the legal standard that would require any off-site mitigation. The acknowledgement itself that there potentially could be nesting sites within 1/2 mile does not constitute new information that would require any recirculation of this document at this time. It's staff's opinion that this disagreement among the experts regarding the location of potential Swenson's hawk nesting sites and the need for supplemental mitigation for loss of any foraging habitat has been fully accounted for in this final EIR that is presented before your commission, and that the record is sufficient and legally defensible, and the recommendation before you is supported by all substantial evidence from our qualified biologist. Finally, CEQA does not require that the lead agency conduct every recommended test or perform all recommended research to evaluate the impacts of a proposed project. The fact that additional studies might be helpful does not mean that they are required, and the agency has the discretion to reject a proposal for additional testing or experimentation. It is staff's determination at this time that another test or recirculation of the document to confirm whether or not there specifically are 3 additional locations where there might be nesting habitats is not needed at this time. The final EIR has been revised to acknowledge the fact that they may potentially be there, and we have incorporated appropriate mitigation measure to ensure that they are not impacted as required under the California Environmental Quality Act. And then finally, again, absent of the presence of the hawk, actually using the property for nesting or breeding, it is staff's opinion that imposing a requirement for off-site mitigation measures do not meet the rough proportionality requirements that are identified under the United States Supreme Court, and therefore not recommending you include any of those recommendations or mitigation measures at this time. With that, I'll turn it over to Ms. Slayton to finish the presentation on this project.
Thank you for that, Mr. Murphy. So staff appreciates all the comments submitted. However, we believe the proposed project has been sufficiently mitigated for and conditioned to ensure compatibility with the adjacent and surrounding land. Staff has reviewed the project in its entirety. The project is consistent with the California Renewable Portfolio Standard that requires investor-owned utilities to increase the sale of electricity produced by renewable energy sources to 60% by 2030 and to 100% by the year 2045. The proposed project is consistent with the adopted goals of the county to develop renewable energy from wind and solar facilities. The project will allow for the usage of existing infrastructure, specifically an electrical distribution line along Bacchus Road, which connects to the electrical grid. It is the opinion of staff that the project is sited in a location favorable to the development of a solar project, as available access exists and there is a lack of dense urban development. The project is consistent with the goals and policies of the county's adopted general plan, and staff believes that your commission can make all the required findings necessary to approve the conditional use permits. The proposed project will also, or is estimated to generate an average of 200 construction jobs with a peak of up to 300 jobs and up to 2 full-time equivalent jobs during the operational phase. The department recommendation for this project is to advise the Planning Commission to certify the environmental impact report, adopt the Section 15091 findings of fact and Section 15093 statement of overriding considerations, adopt mitigation measure monitoring program, approve conditional use permits subject to conditions, and adopt the suggested findings as set forth in the attached draft resolutions. That completes staff's presentation. I believe the applicant has called in and would like to give a presentation as well.
Thank you, staff, for that presentation. Madam Clerk, the applicant says called in. Can we proceed with allowing them to speak on the project?
Hello,
Yes.
this is Audrey here. Are you able to hear me?
Yes. Would you may please
Great.
pronounce your name and spell your last name for the record, please?
Audrey Copeland with Lend-Lease.
Thank you.
So I'm going to go through the presentation that I believe is up in front of you. So I'm the lead developer for the AV Apollo Solar Project. And first,
I apologize to cut in. We do not have the screen up for the project, so can we give staff a minute on this, please?
sure, yeah, I'm seeing it now.
So, and click, it's up now, okay. Okay,
Okay,
now you may proceed, thank you.
Okay, great. So as I mentioned, my name is Audrey Copeland. I'm with Lend-Lease Energy Development and the lead developer for the AV Apollo project. First, good evening, commissioners. Thank you for your time today. Really appreciate you hearing the information about this project. I also want to thank the staff. I know this has been a long process to get to this point, and many thanks for your time and effort on the CUP and the EIR. The following presentation is rather short. The objective is to go over some of the economic benefits of the proposed project and share those with the commissioners. So the next slide, slide 2, there on the screen. The project is a 60 megawatt project, as was shared by staff, located on approximately 500 acres. There's 3 different portions to the AV Apollo combined permit, and each of those represents a landowner. So one of the benefits to the community is the ability to purchase or lease the property of these landowners. We have agreements in place. The project also generates energy to supply clean energy to 11,000 homes in California, which is really important to meeting renewable portfolio standards in California and also supplying energy within the local community. Can progress to slide 3. So construction jobs, during the peak of construction, we have 90 jobs. Throughout the course of construction, a number of jobs will be created. The approximate duration of construction is a year of time. And then we will also have jobs after construction. Let's move on to slide 4. Solar projects require maintenance and monitoring. We project over the 35-year project life, we'll have approximately 2 full-time equivalent jobs created in the local community. These jobs consist of washing modules, clearing site, maintaining the site, maintaining the electrical equipment on site, the inverters that are there, and that'll provide some long-term sort of economic opportunity for the community. And then if we move on to slide 5, local revenue, Lend-Lease worked with an independent firm to conduct a study. The Economic and Planning Systems came up with an estimate of local revenue, tax revenue, that would be generated from this project over the 35-year project life. And the projection is between 6.4 and 7 million in local tax revenue. Those revenues support county schools and programs and whatever other kinds of activities there are within the county. Moving on to slide 6, solar projects are obviously not a new feature to Kern County. I still think it's helpful to see an image of what these look like. This is not exactly what it would look like at the site, but we would probably have a solar tracking system. We could do a fixed tilt system or solar tracking system. You can see here the panels are strung together, and then the inverters and conduit lines run, and then that is interconnected to the grid at another point in the system. And slide 7 shows a side profile of the system. The project is not very far off the ground. It's about 4 to 6 feet in height, and will rotate east to west during the day. Just kind of a little bit of a visual there of what it looks like. And that really, if we go to slide 8, that concludes the economic summary. I'm happy to answer any questions that the commissioners might have. We really thank you for your time and consideration. The staff has detailed all the other pieces to the project, so this is just a short presentation. And again, we thank everyone for their support and moving this project forward through the process.
Thank you.
Yeah.
Madam Clerk, are there any other people that would like to speak on this project, either for or against?
Commissioner Judge, there are 2 voice messages that were received by the department that will now be played.
Okay, thank you.
My name is Elliot MacDougall, ELLIOTT MacDougall, regarding agenda item number 1, the AV Apollo conditional use permit. On behalf of the landowners of the property on which the AV Apollo solar project sits, I'd simply like to say how pleased we are with the rigorous environmental review process that has been undertaken on the land. As we will own this property for many decades to come, and likely after the solar project is gone, we appreciate the need to protect the natural environment. The environmental impact report that the county has put together ensures this will happen. We also believe this is the highest and best use of the property and supports the environmental necessity of more green solar electricity. Combining positive goals and strong due diligence, this process of responsible development is a testament to the good work of the county staff, and we add our support to their recommendation that the Commission approve this project's permit today. Thank you.
This is for agenda item number 1, Apollo Solar Project. My name is Jim Elrod, Jimelrod. I am the business manager, financial secretary of the International Brotherhood of Electrical Workers, Local 428. I represent 800 members who perform electrical construction and installation in the Kern County area. With the past support of the Kern County Planning Commission and the county supervisors, we have had over 2,000 megawatts of solar work built in Kern County. And with your support of the Apollo Solar Project, we will be able to continue to offer good-paying jobs with health care and pension benefits to Kern County residents. It has also created opportunities for Kern County residents to enroll in an approved apprenticeship program of the building trades. We have doubled our apprenticeship in the last 6 years because of the opportunities in the solar work that the Kern County has approved. So we ask that the county commissioners approve the Apollo Solar Project and move it forward with a recommendation to approve to the supervisors. Thank you.
Thank you. Seeing that was the last comment, I'll close the public hearing portion for this item. Moving on to any of our fellow commissioners want to make any comments on item number 1. I will turn to Commissioner here to speak on the item.
Sure. I'll go first. I think this project is well put together. It's a great spot for it. There's lots of solar out there already. Makes it easy to tie into the existing infrastructure. I agree with Mr. Elrod's comments. It provides significant jobs for the area, which are much needed. I think it supports California's energy portfolio, which I support as kind of an all-in approach. You know, we need little bits of everything to make up our incredible appetite for energy in this state. I know these two biologists personally, Mr. Uptain and Mr. Dayton, and I know their work. So I'm in support of the project. Good job as well, staff.
Thank you, Commissioner Ashley. Fellow commissioners? Seeing none, I just would also like to comment on the fact that I want to applaud staff on their work on this project. I know that this thing was continued to put some more due diligence in, and the response, especially to the comments regarding the mitigation for special status animals and plant species, that the staff went thoroughly involved to make sure this EIR was held to a very high standard. So I want to commend you guys on that. And I think this is a project that is definitely needed in our county. As with everything currently going on, these projects bring jobs, bring income, and help our grid system. So I am also in support of this project, and from there I would entertain a motion.
I'll motion.
Second.
Four ayes, one absent.
Mr. Murphy, prior to any routing of appeals, we move to item number 2 first.
Let me read the right of appeal first, and
Okay.
then we'll move on to item 2. For projects where the Planning Commission action is final, as is the case for this project, that action is subject to appeal to the Board of Supervisors by any interested person, and no development proposed by any application may be authorized until after the final date of appeal. An appeal may be filed with the Kern County Planning and Natural Resources Department, again located at 2700 M Street, Suite 100 in Bakersfield, with a filing fee of $540 on forms that we have available at the department. Again, they are also on our website. That filing must be made within 14 days of and including the date of this hearing. If no appeals received, the action of your commission is final.
Thank you, Mr. Murphy. Mr. Murphy, turn on to item number 2, CUP number 8.
Thank you, Mr. Chairman. And then when Ms. Simon is ready, she will be presenting that particular project to your commission this evening.
Thank you, Ms. Simon.
Thank you. just going to get settled in here for a quick second. Thank you.
I was waiting for your microphone.
Can you hear me? Thank you. Good evening, Chairman Josh and Commissioners. My name is Antoinette Simon, and I am the Division Chief for Current Planning. While I'm doing my presentation tonight, my glasses may fog up, so please forgive me if I have to take a pause. The request before your commission was continued from the June 11th hearing in order for a clerical error to be addressed within the public notice, and therefore the project was re-advertised, to be heard at tonight's hearing. Staff was also able to evaluate comments and concerns regarding the proposed project raised by nearby residents during that additional time. The request being considered this evening is a conditional use permit that would authorize the construction of a 70-foot tall stealth wireless communication facility and associated equipment shelter where the proposed facility would be designed to resemble a water tower. The applicant for this project is AT&T Mobility by Jerry Ambrose. As I previously specified, the project includes a CUP that would be a permit for a 70-foot tall water tower wireless communication facility, along with an approximate 875 square foot equipment shelter and backup generator. As proposed, the project includes the construction of a minimum 6-foot high masonry wall to visually screen the equipment shelter. The stealth design of the facility is proposed as a water tower, and the building materials for that water tower would be faux wood that would be more durable than wood construction. The color palette of the water tower, including the lattice, would be dark brown hues, and all the finishes would be matte or non-glossy. The project site is located within a 150-acre parcel that is owned by the County of Kern and is located on the north side of Old Alfred Harold Highway. A good portion of the project parcel is developed with California Living Museum, or CALM, which is a local animal preserve. Specifically, the tower would be sited approximately 1,000 feet east of the main parking lot. The project site is designated 3.1 Parks and Recreation Areas by the Metropolitan Bakersfield General Plan and Kern River Plan element and has a zone classification of RF, KRC, GH, which is recreation forestry with the Kern River Corridor and Geologic Hazard Combining District. According to the RF zone district requirements, radio and television antenna, communication towers, chimneys, and other similar structures shall not exceed 80 feet in the height. Along with CALM being located west of the project site, the surrounding properties are undeveloped, naturalized grassland and is sparsely developed with large estate, single-family residences, and a condominium development located to the east, while the Kern River Campground is located north of the parent parcel. Access to the parcel is from Old Alfred Harold Highway. As a reminder to your commission, wireless communication facilities are permitted uses within all industrial zones and require processing conditional use permits in agricultural, residential, and commercial districts. Stealthing of the tower is required if the project site is zoned residential or has a residential general plan designation or on property that is located 300 feet of residentially zoned land. The siting of the wireless communication facilities shall be encouraged to minimize the adverse aesthetic impacts on the residential areas and other sensitive view sheds by co-locating facilities where feasible, and through the use of stealth design technologies by disguising the facility so that it is not easily recognizable as a telecommunications equipment, or other screening and design treatments which seek to harmonize tower siting with the natural or built environment. All proposed towers must not only comply with the base zone district it is located in, but must also be compliant with the wireless communications facilities of the zoning ordinance known as Chapter 19.91. The purpose of this chapter is to establish reasonable guidelines and regulations for the siting of wireless communication facilities, providing non-broadcast services, and include facilities subject to the Federal Communications Act of 1996. While Chapter 1991 of the zoning ordinance is the manner by which Kern County manages communication facilities locally, your commission should be advised that these facilities are also federally regulated in accordance with the Telecommunications Act of 1996. The purpose of the Telecommunications Act, and specifically Section 704, is to foster the growth of cellular and communication technologies, and in doing so, limits local siting in terms of land use authority for those projects when they meet basic development provisions or standards. Quoting from Section 704A of the Act, regulation of the placement, construction, and modification of personal wireless service facilities by any state or local government or instrumentality thereof shall not unreasonably discriminate among providers of functionality equivalent services, and shall not prohibit or have the effect of prohibiting the provision of personal wireless services. The Act also expressly preempts state and local governments from regulating personal wireless communication facilities on the basis of the environmental effects of radio frequency emissions, to the extent that such facilities comply with the FCC regulations concerning such emissions. Further, there have been court rulings that a zoning denial of a permit for a provider because two cellular providers were already providing service in the same area constituted unreasonable discrimination. And under the Telecommunications Act, a municipality may not simply decide that it already has enough towers on that basis to deny the application. To address stealth design requirements, the project proponent is proposing the tower resemble a wooden water tower, which is consistent with the requirements of the Kern County Zoning Ordinance, Chapter 19.91. During the course of processing this request, staff notified surrounding property owners and county departments. As of this writing, 7 comment letters, with 2 letters being in opposition to the project, were received. Staff received correspondence from the Kern County Public Works Department Floodplain Management Section, Kern County Superintendent of Schools, and Caltrans, indicating that they have no comments regarding the project at this time. Staff also received correspondence from the Kern County Public Works Department Administration and Engineering Division, commenting the applicant shall enter into a secured agreement with the division to ensure that all county roads and bike paths are maintained and or repaired as part of the proposal. As I mentioned earlier, staff received 2 letters of concerns. I would like to highlight a few of those comments along with how they are being addressed by staff. Aesthetics. It is important to note that the project site is not located along any existing or proposed air or view shed easements, nor is the tower located within the boundaries of an identified or designated scenic vista. Staff does not believe the tower would result in the property value loss or significant view shed disturbance, given the proposed tower location, which is a substantial distance from all nearby homes. The proposed water tower design would visually conceal all the equipment's antenna and would be painted a dark matte earthen hue and would utilize a faux wood design to better blend in with the surrounding area, providing a visually pleasing aesthetic. It is staff's opinion that the faux wood material of the water tank would complement the surrounding rustic open grassland landscape. Additionally, the proposal will not create a new source of substantial light or glare that would adversely affect day or nighttime views in the area, as lighting is not proposed for the site, and all building materials and paint for this cell tower will be matte or non-glossy as conditioned with the faux wood facade on the water tower. In addition, attached to your staff report is a photograph of what the tower would look like or could look like. This tower was constructed using faux wood materials, and staff is recommending a condition that specifically outlines the design of the water tower. Condition number 2, beginning on page 3 of your draft resolution, reads, this approval authorizes a conditional use permit to allow the construction of a matte, non-reflective, neutral color 70-foot tall wireless communication facility, stealth designed as a water tower with associated equipment shelter, section 19.42.030E, in an 875-foot square lease area in an RF KRC GH district. And A, all equipment shelters, poles, antennae, and supporting structures shall be treated and painted in matte, non-reflective, dark, natural hues such as brown, charcoal, beige. No signage or advertisement of any kind shall be authorized to be established on the water tank unless a formal modification to this conditional use permit is authorized and duly noticed to a public hearing. B, the tank design shall include darker faux wood facade as indicated in the provided designs and photographs and approved by the Kern County Planning and Natural Resources Director. And C, in keeping with employing stealth technology with camouflages, the communications tower in the form of a water tower, the applicant shall submit revised elevations of the tower design to the Director of Kern County Planning and Natural Resources Department for review and approval. The revised elevations shall depict a tapered-shaped water tower that has a more significant diameter at the base and tapers off at the height of the tower increases to the cylinder area of the tank. The water tower design shall reflect a darker faux wood tank design with darker natural matte, naturalistic treatment and paint, i.e. brown, charcoal, beige, etc., for the required attachments and latticed stand base. Final design to be reviewed and approved by the Director of the Kern County Planning and Natural Resources Department. In addition, there is a condition that is also included that requires the applicant install landscaping around the block wall. Noise and lighting was also brought up as a concern. Lighting is not proposed, as mentioned earlier, for this water tower wireless facility, and staff has included a condition of approval prohibiting the use of lighting unless it is required by the FAA. The facility is designed to produce little to no noise and are unmanned unless the site is being maintained. In rare instances, the site could produce 65 decibels of sound if the backup generator was activated. However, the sound would dissipate quickly. The extraneous equipment and generator would be enclosed within the masonry enclosure that would help in buffering the sound should this event occur. Another concern was the Kern County property review. As this site is owned by Kern County, an official agreement with AT&T will not be pursued until such time that the applicant obtains appropriate land use authorization. Your commission is a hearing body that is a county-appointed entity. However, your decisions operate under the criteria and thresholds as required in conditional use permit applications as outlined in Chapter 19.104 of the Kern County zoning ordinance. Further concerns were raised in regard to the Park and Recreation's review for the proposed project. Currently, there are no provisions within the adopted ordinance that specify proposed projects be considered by the Kern County Parks and Recreations Commission prior to your commission's determination. Additionally, the Kern River Parkway Committee and Kern Equestrians for Preservation of Trails were notified for this proposed project. As of this date, staff has not received any comments from these notified parties. Staff has to evaluate the applicant's information and coverage maps on a provider-by-provider basis. There may be other service providers in the area, by another company. However, this does not mean that this is a basis for denying the application. Staff has also consulted with the applicant and confirmed that the wireless facility would provide new Wi-Fi possibilities, FirstNet and emergency response systems, higher data coverage, and higher internet coverage. It should also be noted that your commission has received a new photo simulation and elevation drawing this evening that depicts a different roof pitch and water design. Currently, the design that you have in front of you is a flat roof, which, it's okay. Ms. Monsiváis is putting up on the screen for you. That overall height is 70 feet. The building materials would remain the same faux wood facade as mentioned in condition 2. The new depiction this evening that you have reflects the photograph that was put up a little bit earlier by Ms. Monsiváis that is also attached to your staff report, and it includes a conical roof pitch that resembles a silo roof. This option increases the overall height to 76 feet. The additional 6 feet would be only for decorative purposes and is still within the base zone district's height allowance of 80 feet. Currently, condition 2 and 2C reflects the flat roof design as I read to you. However, should your commission wish for the conical roof design, condition 2 and 2C can be revised to reflect the additional height and specific roof design. This completes my comments. I am available to answer any of the questions your commission may have, and I'm prepared to assist your commission in crafting any other appropriate language for a motion based on the comments you provide.
Thank you for that. Madam Clerk, is the applicant here to present online?
Chairman Judge Jerry Ambrose should be on the line. If you can dial *6 to unmute your microphone.
Can you hear me?
Yes, we can. Please state your name and spell your last name for the record, please.
Yeah, good evening, Commissioners. My name is Jerry Ambrose. I'm here on behalf of AT&T. That's AMBROSE. I don't have anything to add right now to staff's presentation, and I'm here to answer any questions you may have.
Thank you.
Thank you.
Any questions for the applicant from fellow commissioners? Okay, thank you. We'll get back to you if we have any additional questions. Thank you.
Okay, thank you.
Are there any other members who would like to speak on this project?
Commissioner Judge, there have been no additional comments received.
Seeing no more comments, I'll close the public hearing portion of this item and turn to our fellow commissioners for any item.
I have a question for staff, Mr. Chairman.
Yes.
Just to clarify, is there a CEQA requirement of any type for this? And then what is the requirement, I guess, if this is on Parks land? Is there any other thing we have to look at in terms of permission, shall we say, I guess, if it's zoned for parks?
If I may, through the chairman to Commissioner McGivney, the CEQA determination that staff made was 15303, which is for the construction of small structures, which this does qualify for. That would be for any structure that is under 2,500 square feet. In addition, as well, for Park and Recs, we looked at several of the, of course, all of the, the thresholds under the wireless communications facilities chapter and under the recreational forest chapter. And one of the specific requirements was that the tower be located away from any residentially zoned properties, which is why the tower is located approximately 1,200 feet from any residentially zoned properties.
Does the property have to be exchanged for anything for, land use shift for parks, or is this just I'm just trying to figure how this is being allocated in terms of, land use.
A wireless communication facility is allowed in the recreational forest district as long as there is an approval of a conditional use permit, and that's why we're before you tonight.
Okay. Thank you.
Commissioner? I have a question for staff. Reading through some of the comment letters, I was reading through the comment letter from the Sierra Club regarding the CALM. And help me understand, so this property is leased by CALM, but the tower, they made reference to fees and annual income. Does that go to the county, or does that get given to CALM for it because they have lease of that property?
Chairman, Judge, if you don't mind, I wouldn't mind responding to
Yes,
that
please,
comment specifically.
Commissioner Craig.
So this is no different than any other project that has been before your commission. The owner of the property is the County of Kern. Okay. There is a lease for CALM to lease a portion of that property. However, the underlying ownership is still the County of Kern. So we received an authorization letter from the County of Kern indicating that this project could be processed. Just like with any other project, there was a negotiation that would take place between the property owner and the applicant in terms of use of that particular land. So that is not something that is subject to our consideration process. We are looking specifically at the proposed request, the cell tower on this particular land. I can't specifically detail what those agreements were, as they were between the General Services Department and AT&T directly. Regarding use of the land, even though it's located within the CALM area and Hart Park, there is no specific provision that requires that the Parks Commission specifically give any comment on this particular project before it's considered by your commission. It's just like with any other entity that we have or other organizations. They have an opportunity to review it. They can decide as a group that they wanted to provide comment letter to General Services and say, we are in favor of this project, we're opposed to this project, anything along those lines. It's very similar to like the Rosamond Town Council. The Rosamond Town Council, they review projects all the time that are down in the Rosamond area, and then they as a council provide a public comment on the proposed project. So the Kern County Planning Commission would do the exact same in this particular instance, or they would specifically comment to the General Services Department, as that is who staffs that particular commission. So again, there's been a number of instances where cell towers have been proposed on parks that the county has owned and operated throughout the county. And again, the only difference is this project is located within the Kern River corridor area and adjacent to Hart Park and CALM. And then to answer a previous question from Commissioner McGiffney, yes, we look at the underlying land use. So the RF, this is a use that is allowed under the RF, but we do look at all the other adopted projects or plans that have been in place. So for example, there's a parkway that this project will have to utilize. We reviewed that plan and we have specifically put conditions on this project to make sure that if the pathway is damaged in any way because of this particular project, that it will be repaired back to the status that it was ahead of time. So again, in looking at, we tried to understand the aesthetic concerns related to any development within the park, because that's an enjoyable piece of property that a lot of residents enjoy and is a treasure for the county. That is why we are recommending the tower, the water tower as opposed to a tree. We try to look at what is the appropriate balance and what is the appropriate aesthetic that would fit into the area. So in kind of looking, what was it, CALM? Again, that's where the discussion came and said, you know what, we think this is the more appropriate use. And then again, one of the reasons this was continued is the first design we saw, we did not think it matched as closely as it could. So AT&T graciously said, you know what, I can redesign it, make it a little bit more symmetrical, not make it to where it looked like it stood out as much. So we believe that this was the best design, looking at both the land use, the concerns of the residents, the use of the park adjacent to CALM, and the campgrounds and everything that are around the area. So that's kind of what we did, and that's the options that we brought for you tonight. We did want to make sure, is because we did get those designs submitted after the staff report was done. If your commission believes that the more conical roof pitch is more appropriate, staff is prepared to show you some revisions to a condition that would make the tower have that roof pitch. Otherwise, as it's currently proposed, it would be a flat roof, and it would not have that shape. So, we're looking for your commission to provide guidance as to which you think is more appropriate, and then we have the appropriate conditions. We can revise that accordingly.
Thank you, Mr. Murphy. And looking at the overall design, I want to commend the revised of this. I think this looks actually quite nice. I think the rustic look of the water tower fits that area. I think it is, I don't feel it to be an eyesore. I think it blends in quite nicely. But I would like to make the recommendation that we modify the tower to give a conical roof, but I think that would complete the water tower aesthetic look. And I think it gives the project a better feel to it. So if any of the fellow commissioners want to comment on that item.
I agree with you, Mr. Judge.
If you won't mind, just so that you have it as the basis of your discussion, if Ms. Matsubias or Ms. Simon could show the condition revisions, and if Ms. Simon could read what the proposed revision to condition 2 would be, if that is the direction your commission would like to go.
So commissioners, the condition number 2 would read as I had read earlier in my staff presentation. However, instead of it stating 70 feet, it would be 76 feet tall. And then under 2C, it would read, roof design shall be of conical roof pitch. That would be the only revisions to that condition. And that should cover what you see in the elevations and in the photo simulations.
Okay, I think we'd like to add those comments onto the condition of the project. And any other comments prior to making a motion? Seeing none, entertain a motion.
I would move to approve the project with the amended condition that it has the pitched roof, as Ms. Simons described.
I will second that motion. Four ayes, one absent.
Okay, Mr. Murphy, you want to read the right to appeal on this?
I will. Thank you again, Mr. Chairman. Again, for projects where the commission's action is final, this action is subject to appeal to the Board of Supervisors by any interested person, and no development proposed by the application may be authorized until after the final date of appeal. This appeal may be filed with the Kern County Planning and Natural Resources Department, located at 2700 M Street, Suite 100 in Bakersfield, with a filing fee of $540 on forms that we have available at the department and on our website. That filing must be made within 14 days of and including the date of this hearing. If no appeals received, the action of your commission is considered final.
Thank you, Mr. Murphy. Now let me try this again. How about adjournment?
So moved.
Yes.
Second.
All in favor?
Aye.
This meeting has been adjourned. I was trying to get you guys out here early.